For today's story, we are talking about Joe Biden's student debt relief plan that was announced relatively recently. As I'm sure you all know, those of you who have student loans, myself included, I'm sure had some notice or some interest when the Biden administration said they're going to relieve $10,000 worth of student loan debt or $20,000 worth of Pell Grant loans. That sounds nice and all. But one of the questions is, by what authority, by what right is Joe Biden doing this? Because his authority is a little bit nebulous. And so, well, is this legal? Well, one of the challenges, of course, in challenging any law is finding someone who has standing, someone who's been harmed by it. So is it legal? Questionable. Has anyone been harmed by it in a way that would allow them to sue? Well, some people have already tried, and to certain degrees of success. So this article is covering some of the legal challenges that have been filed so far dealing with the Biden debt relief plan. So let's go ahead and get started with this article. The antipathy many conservatives feel towards President Biden's student debt relief plan, which the nonpartisan Congressional Budget Office estimated to cost $400 billion, is as vivid as many borrowers' enthusiasm for him. The president is not king, he's not emperor. If he does something unconstitutional, I'm going to hold him accountable. I mean, would be nice, but just because it would be nice doesn't necessarily make it legal. And just because something's bad doesn't necessarily make it illegal. Law does not turn on morality, as we've discussed many times. I can assure you, me and my Republican colleagues and I will fight to the bitter end against this illegal, abusive use of the executive pen, said Representative Virginia Foxx in a recent speech. Both parties tend to over-abuse executive power because it's just too tempting when you have it. No one when they're handed the power wants to be like, I don't want all this power. So yeah, getting someone to actually give up the power or constrain the administrative state has been a bit of a problem. And both Republicans and Democrats have used executive orders in excess of what they were designed to do, sometimes illegally. In a memo defending Biden's plan, the U.S. Justice Department cited the HEROES Act. So what is our authority to do this thing? Why is it legal? What congressional authorization? Well, the HEROES Act, which George Bush signed after the attacks of September 11, 2001. I believe it went into law 2003, specifically. So there was a law put in place that basically, in short, allows the federal government to forgive interest or debt in response to a national emergency, such as, for example, 9/11, where this was passed in response to. And so they're trying to use this authority, which was created for these sort of grave emergencies. And we're trying to say that we're in that kind of grave emergency now, at least in part to COVID, which I don't know about any of that. That's the authority they're trying to use. I don't think it was meant for that. What the text supports or not is a whole nother set of discussions, right? So if you're a straight textualist, you might look at this one way. But if you're looking at this in terms of the original purpose, it's a little bit hard to squeeze it into what the law was designed to do. What it does do, of course, is a different discussion. The act gave incredible power to the U.S. Secretary of State to alleviate hardship federal student loan recipients may suffer as a result of a national emergency. And of course, now we're trying to use the HEROES Act to freeze payments. The Trump administration used the same HEROES Act to freeze payment and interest on student loans. President Biden, of course, not only extended the payment freeze, but citing the same authority, canceled the debt. $10,000 in student loan debt for any borrower who earns less than $125,000 a year, and $20,000 for any person who has Pell Grants. The Biden administration argues if Republicans feel the debt release is an abuse of power, why didn't they oppose President Trump's use of the same authority? Because both parties are hypocrites when it's their guy, is basically the short of it. That has not been challenged in court. It's not been found improper in court, said the deputy director of the National Economic Council. It's the same statute the previous administration used and we're doing and are now using for this action. Yeah, this is the unfortunate aspect of, having standards and having to apply them both ways. It's not okay just because our guy did it. It doesn't work. You have to have consistency if you want to have principles. Opponents of Biden's debt relief plan have been clear. They think it's an illegal abuse of power. Congress controls government spending, they argue. Sure. Any sort of spending from the purse must be authorized by Congress. And the president simply can't erase student loan debt without going through lawmakers. Well, he's arguing that he has congressional authorization. That's the problem. The courts can only get involved when someone who's actually been harmed files a lawsuit. That's one of the key aspects. Who's been harmed by this? So whether or not Biden can do it or not, who has the basis to sue? The courts can only get involved when someone who's been harmed in a concrete way files an action. Who, therefore, can argue they've been hurt? Standing is a real hurdle, though it's a hurdle, not a wall. It's a little wallish because who is harmed? Several types of plaintiffs could potentially clear standing hurdle. First, a borrower, just not any borrower. The harm has to be automatic, and most borrowers who qualify for debt relief will have to apply for it. That's not automatic. Now, someone actually has sued about this already. Someone has already sued saying they would be harmed by the automatic debt relief. Their argument, and I can't speak to its legal veracity in the particulars, not for the least of reasons, it involves tax law and state tax law at that. So I don't know. But his argument was he would be harmed by the student debt relief because the debt relief would count as income for the purposes of some sort of state taxing authority. And so he would have all that income now, and he had to pay tax on it now. Whereas he was under some sort of repayment plan, I think from his employer or whatever. The details I'm a little fuzzy on. But if he paid off, if he did it over the next 4 years, his debt would be forgiven, but he wouldn't suffer the tax consequence. So he argued the automatic debt relief would harm him because it would incur some sort of state tax liability that he wouldn't otherwise have to pay. And that was his argument. Now, the Biden administration mooted the issue because although he sued, the Biden administration just responded immediately in court by saying, okay, well, we'll make sure that anyone can opt out. And as for you in particular, we are taking your lawsuit as an opt-out request, and we've already made sure your debt will not be relieved. So your harm is solved. You will not be receiving the automatic payments. You got exactly what you wished for. So yeah, it's like, okay, well, if anyone who has been harmed by automatic payments can opt out and everyone else has to opt in anyway, who's harmed by it, right? Yeah, not so much. In a lawsuit that had been filed, but as I mentioned, has already been resolved, a borrower named Frank Garrison, who was an attorney based in Indiana, argued that he would have been harmed by the plan. Garrison says he could qualify for the $20,000 of automatic loans, but Indiana is a state that would tax that relief as income. He doesn't want the tax relief he doesn't want the hits because he anticipates that through the Public Service Loan Forgiveness Program, he will receive the wiping out of his debt without having to pay any tax. And then, of course, they mooted the issue instantly by saying, yeah, okay, we'll make sure everyone who wants to opt out can, and you don't have to, we've already opted you out, so you're good. You can continue paying for your loan. So problem solved. The court has written, in view of the fact that the Department of Education exempted the plaintiff from receiving debt relief, the court finds no irreparable harm. Problem solved. You got what you wanted. Yay. All right, so that deals with an individual plaintiff who would be harmed by the debt relief. You can either not apply for it, or if you would have received it automatically, you can opt out. So that takes care of any harm from any individual. How about non-individuals? While Thursday's denial appeared to close the door on that legal strategy, another has opened. 6 states have sued the Biden administration on behalf of state-based loan services and investment entities that manage old privately held federal loans. The loans are guaranteed by the federal government, but often issued and maintained by outside groups, including private banks. These loans were a mainstay until the program ended in 2010. More than 4 million borrowers still have these kinds of loans. Until Thursday, the department advised these borrowers that they could consolidate these loans into federal direct loans and qualify for relief. In Thursday's lawsuit, 6 states argued that allowing these program borrowers to do this, consolidate their own loans to qualify for consolidation, could hurt the state-based loan agencies, arguing, quote, the consolidation of the loans harms the entity by depriving of the asset, which is the loan that it currently owns. I don't think so, personally, because you're getting it paid off, right? You're just getting paid. So, I mean, Yeah, the consolidation of loans harms the entities by depriving it of ongoing interest. But the problem is that they were never entitled to the interest as a matter of law, as best as I understand, because I don't believe any of these loans prohibit prepayment. You can always pay more than you're required to. So anyone could have paid off these loans at any time. You were never guaranteed the interest. So I'm not quite sure that's a harm either. But in response, the department quietly reversed guidance for those kinds of borrowers. An administrative official told NPR the move could exclude 800,000 borrowers from the relief they had promised, which I think I might have some of those loans. So that's bad news for me personally. The sudden change not only angered borrowers, but advocates. The Biden plan would provide life-changing relief to 40 million students. I think reality is no matter what they do, they'll face a politically motivated lawsuit. But better than playing whack-a-mole by eliminating relief for some borrowers, it'd be great to see them defending their plan. It's not yet clear if the department's change, limiting the number of borrowers who can qualify for debt relief, will undercut the state's claims. Yeah, I'm not really sure the states have any claim here, because, again, while they do administer the loans, and it's true, the loans are an asset, the loans, as I understand them, can be paid off at any time. So, although you might have in some sense anticipated the interest, you were never guaranteed the interest, right? You're only guaranteed the interest on unpaid debt. If they pay off the loans, you have no unpaid debt, so you have no harm, right? The fact that everyone is paying off their loans all at once is still not a legally cognizable harm, because that was something that your agreements always allowed the possibility for. So there's no harm to you because it's within the terms of your contracts, even though there's lots of them. So I'm not sure there's any harm there either, but that's what they're debating about. Also, the Arizona Attorney General has filed a lawsuit and taken a slightly different tactic. He argues the debt relief will deprive Arizona of important future tax revenue. I'm not quite sure how. He also suggests relief will hurt the economy by exacerbating inflation. Seems too tangential, not specific enough. Increase the state's borrowing costs, how? And increase the law enforcement costs of cracking down on debt relief scammers. How? How would it do with those things? But the first harm may be the most interesting. He essentially argues the broad debt relief will nullify the impact of public service loan forgiveness program. Simply discharging the debts he writes harms the Office of the Attorney General's ability to recruit legal talent. Oh, okay. So you were bribing them to get the attorneys to work for you. And now that you can't offer them this bribe, although you could just offer them the money, incidentally, right? You could just pay them. That would be fine. But now that you can't offer them student loan forgiveness debt, they might not want to work for your office. That's not saying a lot for your office, you know, personally. And also you could just pay them still. I mean, you could offer them a bonus contingent on a number of years and basically do it the same way. So I'm not sure that's a harm either, but okay. If a lawsuit is allowed to proceed, of course, the opponents say they would seek an injunction, which if granted would allow the courts to freeze all this in place. What's not clear is whether injunction could come before some borrowers see their debt erased, which, you know, the moment the forms become available, if I'm available, I will definitely be filing them. We don't want to create a situation, you know, where a bunch of people are in limbo, and I think it's incumbent to file a lawsuit as quickly as possible. Conservative legal groups, of course, are taking notes on all this to make the next lawsuit even stronger. As you should, right? You learn from your mistakes. And so if one legal theory doesn't work, you can try a different legal theory. If there's a legal theory out there, so since the department added the opt-out, that pretty much closes it for every individual. And so there's no individualized standing. The banks don't seem to have standing because they were never entitled to the interest. The fact that, you know, you can't offer this student loan payoff benefit anymore, it's like, no, you can just offer them the same amount of money as a bonus or pay them in cash or something. So if you need to pay people more to attract talent, that is not an option that's foreclosed. So finding standing from anyone is really, really tricky here. So that has been a look inside the legal battle to try to stop the Biden student loan relief program. There have been some lawsuits filed. Some lawsuits have already been resolved. The Biden administration has already made changes to its plan to try to deal with other lawsuits. And it's not particularly clear that anyone really has standing to bring any of these lawsuits at this time. So all that is happening. And we'll see if any of them go anywhere, although I'm not particularly optimistic, but you never know. Someone might come up with a legal theory that works. And at least for the moment, that brings us to the end of discussion of this article.